This article discusses water usage laws in common law. For a discussion of the right to water as a human right under international law, see Right to Water. Water right in water law refers to the right of a user to use water from a water source, e.g., a river, stream, pond or source of groundwater, in areas with plentiful water and few users. Such systems are generally not complicated or contentious. In other areas, especially arid areas where irrigation is practiced, such systems are often the source of conflict, both legal and physical. Some systems treat surface water and groundwater in the same manner, while others use different principles for each. Types of water rights. Fundamental differences exist between the nature and source of water rights in different countries. Generally, water rights are based on the water law that applies in a particular country and, at their most basic, are classified as land-based or use-based rights. Some countries allow their subdivisions to establish independent water laws. For example, each state and territory of the United States has its own set of water laws that establish water rights that may be land-based, use-based, or both. Land-based water rights are based on land ownership or possession. For example, many common law jurisdictions recognize riparian rights, which are protected by property law. Riparian rights state that only the owner of the banks of the water source have a right to the undiminished, unaltered flow of the water. Finnish water rights. In Finland, water bodies are generally privately owned, which is not the case in most EU countries. But Finland also applies the Roman law principle of aqua profluens, according to which the freely flowing water in water bodies cannot be owned or possessed. This means that the owners of water bodies cannot prohibit diversion of water for agricultural, industrial, municipal, or domestic use according to the provisions of the Finnish water law, and cannot prohibit use of the water bodies for recreational purposes. Community-based rights. In some jurisdictions, water rights are granted directly to communities and water is reserved to provide sufficient capacity for the future growth of that particular community. For example, California provides communities and other water users within watersheds senior status over appropriative water rights solely because they are located where the water originates and naturally flows. A second example of community-based water rights is Pueblo water rights. As recognized by California, Pueblo water rights are grants to individual settlements over all streams and rivers flowing through the city and to all groundwater aquifers underlying that particular city. The Pueblo's claim expands with the needs of the city and may be used to supply the needs of areas that are later annexed to the city. While California recognizes Pueblo water rights are controversial. Some modern scholars and courts argue that the Pueblo water rights doctrine lacks a historical basis in Spanish or Mexican water law. Use-based rights do not relate to land and instead rely on whether the water user has legal access to the water source. As a general rule, use-based rights are usufructuary, fully transferable to anyone. Under common law, use-based rights only apply to navigable, in fact waterways in which there is a presumptive easement, often referred to as a navigable servitude. Appropriative water rights are the most common use-based water rights in the United States and are most commonly found in the western states where water is scarcest. The appropriation doctrine confers upon one who actually diverts and uses water the right to do so, provided that the water is used for reasonable and beneficial uses, regardless of whether that person owns land contiguous to the watercourse. As between appropriators, the rule of priority is first in time, first in right. The modern system of prior appropriation water rights is characterized by 5 principles. Exclusive right is given to the original appropriator, and all following privileges are conditional upon precedent rights. All privileges are conditional upon beneficial use. Water may be used on riparian lands or non-riparian lands. Diversion is permitted, regardless of the shrinkage of the river or stream. The privilege may be lost through non-use. Beneficial use is defined as agricultural, industrial, or urban use. Environmental uses, such as maintaining body of water and the wildlife that use it, were not initially regarded as beneficial uses in some states, but have been accepted in some areas. Every water right is parameterized by an annual yield and an appropriation date. When a water right is sold, it maintains its original appropriation date. Appropriative water rights are not always applied exclusively, as demonstrated by California, which recognizes several different forms of water rights concurrently just for surface water. It recognizes a separate set of water rights for groundwater. In-stream water rights are rights that only apply to water in a stream, and cannot be diverted for usage. These rights are most commonly used to protect endangered species or to bolster the number of a threatened aquatic species. History of water rights. In Roman times, the law was that people could obtain temporary usufructuary rights for running water. These rights were independent of land ownership, and lasted as long as use continued. Under Roman law, no land was owned by citizens, it was all owned by the Republic, and controlled by politicians. In medieval times, the common law of the day treated all freshwater streams as static, meaning landowners owned parts of rivers, with full accompanying rights. Landowners could also seek damages for loss of water diverted upstream. Non-landowners did not have use rights, except by obtaining a prescription. Over time, rights evolved from being land-based to use-based, allowing non-landowners to hold enforceable rights. A reasonable use rule evolved in some countries.